The petition for appointment of guardian for a minor. Hi, I'm Darren Findling of the Probate Pro, and we're going to examine SCAO form PC 651. SCAO stands for State Court Administrative Office, PC Probate Court, Form 651. This form is readily obtainable, and you're welcome to call my office. We'd be happy to give it to you free of charge. This form is created by various statutes and court rules. If you look at the bottom right corner with the floating yellow arrow, you'll see the relevant statutes and court rules. We strongly urge you to work with a skilled, competent probate lawyer who knows how to navigate through the petition process. We also understand that sometimes it's difficult to seek the advice of an attorney and expensive to do so. We hope that this particular video will give you some basic understanding of the process, how to fill out the form, how to at least get started. But again, we urge you to work with a skilled, competent probate lawyer. Now, again, this particular form is used in a narrow context. It relates only to minors. And there is a separate process that's used for an adult that is in need of a guardianship. And there's actually separate statutes that relate to the appointment of a person for an adult. This is for a minor. And a petition for appointment of guardian is different than custody. So if you think about custody within two parents who are sharing a child, those two parents will address the issue of custody. Guardianship in general terms relates to a third party. So maybe a grandparent, a neighbor, a friend, and so on. So a parent is a natural guardian. They're the parent. So we're not talking about getting guardianship when a father or mother are seeking it. But we're talking about generally a third party. It's important to understand that because there's a lot of confusion around when to seek an appointment of a guardian. Let's work our way through it after you've identified the county and the file number you're going to file in the county in which the minor is a resident to establish jurisdiction. In the matter of is the name of the minor, the individual, and the last four digits of the Social Security number would be provided there. Now you can see in very small print it says if a parent is incarcerated and under the jurisdiction of the Michigan Department of Corrections, the petitioner must comply with that particular court rule, MCR 2.004B. We're not going to cover that here, but there's some noticing requirements that relate to a parent that is incarcerated. The next section is the name of when it says I and there's a name. That's the person that is doing the petitioning. Now, it may be a person, it could be an entity or an agency, but the petitioner itself is going to be reflected there. And then your standing as petitioner. Are you the grandparent, the aunt, the uncle, limited guardian, conservator, whatever it may be? You identify your relationship by blood or your relationship to the minor, whether you're a limited guardian or some other role. You're the petitioner, you're advancing the petition forward. So remember, with petitions, you file a petition, it's scheduled for hearing, there is notice that goes out to the interested parties, there's a court hearing, the judge makes a ruling, an adjudication, and then an order gets entered. That's the general framework for how petitions move through the court system. Number two identifies the date of birth, female, male, and again, a description that they're unmarried, because when you're married, there are different rules. Even if you're a minor and you're married, there are some different rules here relating to guardianship. You identify the address and then the present location. So this is really to establish the jurisdiction and the venue to be assured that the petition for guardianship is in the right place. Because often people move around and they may start in one county and then move to another state or into another county. The minor is a citizen of the following foreign country. If there's a foreign country involved, that section is identified. As well as if the minor is a Native American, and they use the term an Indian child as defined under the court rule. We're not going to go into that, but again, if the person is a Native American under that court rule, that box would be checked. Now, if you're unsure, you check box 3B, because there are some specific rules relating to people that are defined under the court rule and statute as an Indian child or Native American. Section 4 is the interested persons provisions here. Now, parents are reflected there. You'll see in the first and second box, as well as their address. And if one of the parents is a minor, the date of birth would be reflected. If they're an adult, you just write adult or full. If there's a conservator, if there's a guardian, and the person with the care and custody of the minor. These are the interested parties as defined under the court rule. There's a court rule 5.125C19. That court rule is reflected at the bottom right corner of this particular form, but it identifies who the interested persons are for purposes of a petition for guardian of a minor. In this case, both parents. And again, I get asked this question a lot. They'll say, well, that person isn't involved in their life, that mother or father. Well, no, the court rule requires you identify them. It's a requirement, not how you assess their level of involvement. The conservator, this would be an individual appointed by the court and deemed to be the conservator. They're reflected here as well as a guardian or limited guardian, and the person that may have the current care and custody but without legal authority would be reflected in the last box. Again, there's some technical aspects here. You want to be really careful that you do this part correct. With all of these SCAO forms, you're completing them under the penalties of perjury. You're answering the question to the best of your information, knowledge, and beliefs. You have to be really careful to make sure you fill it out correctly. And even also, quite importantly, is that when you go to file it, and you don't want to get to court and just simply have the petition rejected. So make sure you take the time to fill it out correctly. And if you're unsure, seek counsel. The back side of this form gives some additional information. If neither parent is living, then there is a rule about who are the other persons that are entitled to notice. So if both parents are deceased, then some additional names may be reflected there. If any of those people are under a legal disability, they use the term legal incapacity, you'd reflect that there. So for example, if one of them is a minor, if they're under guardianship, etc. Now section 5 is a reflection of whether there is other family division circuit court jurisdiction of the family or members that's currently pending. So you have to reflect that, because if there's already a custody dispute going on in the family division of the circuit court, and then this petition for guardianship is filed, they have to be potentially joined or connected. So you're reflecting the existence of that and whether it remains or is no longer pending. The next section is what you're really asking for. Why is there a need for a guardian of a minor? The minor is in need of a guardian. Let's kind of work our way through this. Section A, the parental rights of both parents or of the surviving parent have been terminated or suspended by either death, disappearance, confinement, which would be jail often, judicial determination of incapacity. Maybe they're both under guardian, or maybe they both died, or maybe one's in jail and one has died. These are examples. A previous court order, other than an order appointing a limited guardian of the minor, or a judgment of divorce or separate maintenance. So again, these are bases under 6A. 6B is another type of basis upon which you may be seeking guardianship of a minor. The parent permits the minor to reside with another person. So now in section A, the parents aren't actively cooperating. Maybe they both died or they're incarcerated. In section 6B, there is cooperation because the parent is permitting the minor to reside with another person. So let's, as an example, the parents say to the grandmother, "Grandmother, we'd like you, the minor child, to reside with you." And they don't have the legal authority in some way for the care and maintenance of that individual. So that's section B. Section C is when two biological parents were never married and the custodial parent died or has disappeared, and the other parent has not been granted legal court order through a custodial order. And then it provides that the proposed guardian is related to the minor within the 5th degree by marriage, blood, or adoption. Again, a little bit technical here that we're not going to cover, but another basis. And Section 7 is if there's a temporary guardian, maybe there's an emergency need for guardianship. I'll give an example. Often in a tragic accident in which mother and father both die, and we have to have immediate guardianship put in place to protect the minor child because both parents have been tragically killed. This may be an example, a very sad example, of when a temporary guardian would be needed, and that box would then be used. So a temporary is for a period of time, kind of a defined period of time. It's not intended for long term, and it's often an emergency basis to seek that appointment. The next part is, what are you asking the court to do? And there's a lot of repetition here, but you're asking for somebody to be appointed guardian. And here, the petitioner may not be the person that's being asked. It may be that the petitioner is seeking somebody else to be appointed. And then Section 9 provides some aspect to the order itself. Are you asking for reasonable support, parenting time, or contact with the minor? Now, again, I mentioned that there's a penalty of perjury clause there, so please examine the form carefully before you sign. There's actually two spots for petitioners, because if there's a mother and father, for example, as co-petitioners, there's a spot for both. And in Section 10, if the minor is 14 years or older, the minor can actually make a nomination. So, for example, if there's a petition seeking the appointment of the aunt, and there's a 15-year-old, and the 15-year-old says, yeah, I do want that aunt to be appointed, you can check box 10, and then the minor who is 14 years or older can consent to the appointment of the aunt. And that's a part of this form that gives a voice to a minor who's 14 years and older. They can actually make a nomination as to who they'd like to serve as their guardian. Again, a lot going on in this petition, not the easiest or most intuitive thing to work your way through. I hope that this has given you some good framework and guidance for how the process works. And I've, in other videos, shown exactly how that timeline flows through the court system. So if you want additional guidance on that, watch some additional videos on the process. But again, working with a lawyer is going to make this process a lot easier and smoother for you, because it's not a simple process to navigate through. At the Probate Pro, we are passionate about everything probate. If you have a question about a petition for guardianship or any probate or trust related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.